Hi, I'm attorney John Cann with Cann& Associates, your fierce advocates. And in this video today, I'm going to speak to you about federal gun laws, what they are, who prohibited persons are, and what happens if you are caught or charged with a federal gun crime. I'm sure many of you are aware of our Second Amendment rights or the right to bear arms. However, that right is not absolute. And there are circumstances in which federal courts or federal law enforcement can prohibit you from federal firearm possessions. In this video, I'd like to speak to you about what those criteria are. And really, it comes down to if you fall under a certain category that makes you a prohibited person under federal gun charges. The primary law that federal prosecutors and law enforcement use to prosecute individuals that are prohibited persons from possession of firearms is Title 18 U.S. Code Section 922 and 924. Under these laws, if you are a prohibited person and you own, possess, sell, transfer, manufacture, or basically do anything with a firearm, you may be prosecuted under those laws. So, to the real key of this video, who is a prohibited person? There are 6 criteria under the federal rules that if you fall under, you are a prohibited person and could be prosecuted in federal court for having a firearm. First and foremost, the most simple criteria, being a person under federal felony indictment. This includes people with federal felony charges, state felony convictions, or state or federal misdemeanor offenses that carry greater than 1 year in jail. The second criteria that makes someone a prohibited person is if you have been subject to a conviction under military tribunal. Now, that's not sufficient if you have non-judicial punishment or some type of administrative law action. This must be a uniform code of military justice action or equivalent that a military law judge sat on and you received a conviction in that tribunal or by agreement in that military justice action. The third factor that may make you a prohibited person is if you are a fugitive from justice. Now, this is one of the gray areas that it may be unclear whether or not you qualify. However, if you have an active warrant from a district court, you may be subject to this prohibited person without having received a conviction. The fourth factor that may make you a prohibited person under federal law is really a combination of a number of things. One, if you are an illegal alien, someone who is in the United States unlawfully, as well as someone that has been adjudicated mentally defective or having been committed to a mental health institution. Additionally, someone that's been qualified as being a drug addict or someone dependent on illicit drugs. Now, these categories can be clear or unclear. It is important to know if you fall under any of these, there's a potential of being prosecuted for federal firearm possession. The fifth thing that may make you a prohibited person under federal firearm charges is if you were dishonorably discharged from the military. This is something that happens at the conclusion of a military justice action, oftentimes that coincides with some amount of confinement. However, if you subsequent to your discharge are able to upgrade your military discharge at a later date, then this factor making you a prohibited person would be removed and you could again possess a firearm. The sixth and unfortunately most common type of prohibited person that we see is someone that is subjected to a final protective order or someone with a misdemeanor or felony conviction for domestic assault and battery. Unfortunately, we've seen many clients facing federal firearm charges when they had no idea that they were a prohibited person. It's important you know your gun rights and know what will take them away in the federal context. If you have questions about this or other issues in federal court or firearms, we ask you to visit our website for resources or call us for a free confidential case evaluation.